I studied this for well over a decade, looking into the process in which you can actually find all the elements to file a 1983 or civil rights violation against a judge. Don't pay too much attention to my title because I am pro se. However, the requirement for any cause of action is you must have all the elements for it to succeed. I'll start with, we're going to use her signature. This is on the judgment sheet. I'm going to turn it around. The person I'm suing is that lady right there, the presiding judge of the 185th District Court in Houston, Texas. There's my cause number, clerk volume number. They made me put my thumbprint on it, and this is what I want you to pay close attention to. 11/28/01 at 11:30 a.m. Appeal is taken 11/28/2001. 2001. It's all good. All you attorneys, don't worry about the tolling. Equitable tolling is going to be taken on this. That's my latest notary. Now, here's the catch-22. You first have all the elements. Counsel of record is a requirement for fraud on the court. Fraud on counsel of record, dates, pro se litigant, and if we look down here, Susan Brown signs again, and it's indicating pro se, this person, which is me. This document was created on that day. This is the key document again. Court reporter's notes. The judge, the bench, and I are talking. On the date 11/28. At no mention in this date is there a request for an assistance of counsel. This is a pro se presentation on appeal. Court tells me what to do. Reading at the bottom, I leave you a little time to read it. And I need a transcript. She tells me what to write. Okay, that's all it says, and you need to do that, and there we go. It says adjournment. This is the certification of that court reporter. This is one of my latest notaries to my documents. All right, on that date, there's my signature, guys. She actually indicated the correct date. This little thing, to those who are not in the legal profession, means defendant. So she granted me the right to proceed pro se, and I get the transcript. Volume number. Now, if anybody's familiar, back in the day, we had Tropical Storm Allison. She had destroyed our law library. So I made a request for counsel. They may even try to argue. I think I put a word rescinding. I wasn't a lawyer. They had just ran me through a jury trial. But what I want to note, this is a request, RA. And she says, please appoint Susan Adams. And that's her little John Scriggly Hancock right there, guys. But the date on this is critical. This is December 10th. At no point, in fact, I mailed it from the jail on the 6th. At no point is there a request for a counsel before this. Now, this is where she broke the law. I needed a full transcript. I had a retrial and a mistrial. She wanted to keep the mistrial out of the record where the witnesses just totally changed their story. This is perjury. She says defendant is represented by counsel in this. And she signs it to the appeals court. December 28th. She hadn't appointed a counsel. That is a statement of perjury to the First Court of Appeals. So I had to give it to her and forward it to them. Okay, so that goes on and on. Time passes, guys. I don't know what's happening. Some things have happened, and this is all the stuff that I put in my thing. So finally, that request back on December 10th, I got it January 28th. Okay? When you're in prison in Texas, you get this little yellow piece of paper that I superimposed over here, and it's the date that I actually received it. I put the 30th is when I actually got it. So that's that 131 is when they gave it to me. Why did I sign the 30th? Okay, I was behind the time. They said it was the 31st. Anyway, so there's no way that this document can be true. I signed it. See my signature up there? But when it got back to Harris County, here's the little trick. Look what they did. November 28, 2001. if you set the two documents next to each other, you have them actually backdated, about 67 days. So they took that order, backdated it 67 days. For what reason? Let me see, I need to get her. Oh, there she is down there. See her down there? Judge Brown. They did it because of that lie right there. Where was that lie? They had to make that lie the truth. That is a complete case of fraud involving counsel, the fundamental matter of the trial process that keeps a defendant from presenting itself.